The meeting will begin in 3, 2, 1.
My name is Ricky Bauman. I am the chair of the Hillsborough County Land Use Appeals Board, and I am calling the meeting to order. We have in attendance Mr. Tom Hisney, Development Services staff, Ms. Sonia Rodriguez, Manager of the Citizens Board Support, Mr. Cameron Clark, Assistant County Attorney. On my left, Jerry Campbell, board member. On my right, Vice Chair Bradley Cornelius. To his right, Mr. Justin Evans, board member, and online, Mr. Peter Schwartz. This board is an appellate body and shall only consider the land use hearing officer's decision and the record. This hearing shall be limited to the record on appeal as defined in LDC 10.03.03.h and consist only of limited oral argument based upon said record. No additional evidence may be submitted or considered by board members. The order of presentation will be staff's introduction, petitioner's case, opposition's case, rebuttal by petitioners. Only the following have standing to appeal or to intervene in appeal which is filed or may be heard at this hearing: the applicant, the administrator, any person or entity which appeared before the LUHO and presented testimony or other evidence or presented evidence themselves or by proxy to LUHO and was adversely affected by the decision of the LUHO. The board reserves the right to limit presentation to 10 minutes per side. This time limit may be extended for a good cause. Pursuant to this reservation, the presentation is hereby limited to 10 minutes for each side, with rebuttal limited to 5 minutes. The basis for a good cause extension: case reasonably requires additional time. Proposed additional presentation is relevant. Proposed additional presentation is non-cumulative, the amount of time used to answer the board's questions. The board shall have the authority to uphold the land use hearing officer's decision or to remand the case back to the land use hearing officer. If the board remands a case back to the land use hearing officer, the board shall specify the reason for the remand and specify the issues for the land use hearing officer to address. Ms. Rodriguez, are we hearing the second appeal today?
Yes, ma'am.
Thank you. The board also has the authority to overturn the decision of the land use hearing officer only if all of the following criteria have been met. The case has been remanded one time by the board to the land use hearing officer. And based upon the record on appeal, if the board finds that one or more of the official findings of fact and the conclusions of law as found in the decision of the land use hearing officer is unsupported by competent and substantial evidence in the record, or if the essential requirements of the law have not been followed, and a supermajority of 5 board members vote to overturn the decision of the land use hearing officer. If the board overturns the decision of the land use hearing officer, the board must make findings of fact and conclusions of law. The board may accept, reject, or modify the land use hearing officer's findings of fact and conclusions of law in making the final decision. In addition, the board may impose reasonable conditions on the permit request if granting the request. The board reserves the right to pose questions to staff, petitioner, or opposition at any time. The decision of the board will be rendered at the conclusion of the hearing and shall be reduced to writing. The decision of the board is final, but it may be challenged as authorized by state law by any person with standing. Ms. Rodriguez, please administer the oath.
Everyone giving testimony, please stand and raise your right hand. If you'll be speaking, you must take the oath. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated.
Ms. Rodriguez, do we have Appeal 21-1309 present?
Did you want to approve the minutes first, or do you want to go straight to the case?
I think we could go straight to the case and do the other stuff at the end.
Okay. So we're going to go to page 3, item 2A, appeal number APP 211194, petition file number variance 200951. This is a remand. The appellant is Stephen W. Price. The representative is Ann Pollock Fletcher Fisher Pollock, PL. The property owner is Stephen W. Price and Marcella G. Price. The petition request is to appeal the decision of the land use hearing officer who denied a request for a variance to allow the creation of 3 single-family lots to be served by septic tanks in the urban service area to accommodate the proposed subdivision of the property zoned ASC1. The location is 7205 Potts Road. The size of the property is 4 acres, more or less. The existing zone is ASC-1, future land use RES4, service area urban. The date of the land use hearing officer were August 17, 2020 and June 21st, 2021. The date of the first appeal to the Land Use Appeals Board was April 9th, 2021.
I believe we have Ms. Pollock representing Mr. Price.
I don't believe she's present.
Then let Mr. Price testify, please.
Mr. Price, please state your name and address for the record.
One moment, please. Let's make sure I got it. Good afternoon, ladies and gentlemen, members of the board. My name is Stephen Price. My wife, Marcella, and I are the owners and residents of the property at 7205 Potts Road, Riverview, 33569. And the basic drawing of the property is on the screen there. There we go. That is how it currently exists at this time. We're here today once again to discuss the variance request, which would allow 1 new septic tank on the property, thereby allowing us to split the property into 3 lots. The lots would meet the county's minimum requirement of 1 acre per home while also achieving the 75% density goal set forth in the urban density plan. My wife and I inherited this property in its current configuration. The process of splitting the property was actually begun in 2007, long before we inherited the property. First, there was a request to subdivide the land, and we were told, no, you don't need to subdivide. All you need to do is reparcel the property. So the process was begun. The survey was completed, and even an EPA environmental study was paid for to ensure that the reparcel would not cause any negative impact to the surrounding area. The results were negative, and we attempted to move forward with the project. However, my mother-in-law became ill, and the project was put on hold. In 2012, after her passing, we began again, only to be told different information each time we spoke with county personnel. Finally, I had a meeting with the planning board on the 19th floor in downtown Tampa. Everyone signed off on the reparceling process until someone said, wait, you can't reparcel. You don't have enough road frontage. As a result, I was told we had to create a subdivision with an easement. That should, and yes, okay. If the property had been turned 90 degrees to the road, there would have been more than enough road frontage to allow a simple reparceling of the property. Things just got a lot more complicated, especially for a simple homeowner. As a result, we eventually handed the case over to a land use attorney because the county's processes became so difficult and complicated. It was determined that we now, because of the creation of the subdivision, had to have a variance for a third septic tank to allow for the dividing of the property. Please keep in mind that your decision today must be based on the codes and the spirit of those codes that were enforced at the time of the initial variance request, which I have of July 2020. I don't believe we were heard until August. At some point in the past, the property was rezoned from agricultural to urban service area. The importance of this is that the county entered into a contract with the residents of this urban service area. The county says that they will provide the properties with county services, and in return, we are obligated to use those services. The county has never fulfilled their portion of this contract. The services have never been provided for us to utilize. Therein lies a significant hardship that has been created by the county. No services are available. The nearest county sewage system is 6,730 feet away, and the county has no plans to bring the services into the neighborhood. Because we are required to create a subdivision, many thoughts are conjured up when asking for a septic variance. The code was written to stop multi-million-dollar companies from buying up large lots of land, cutting them into hundreds of individual home lots, and providing the sewage service to each home via a septic system. The code, and even in the spirit of the codes, were never intended to prevent situations such as ours from being approved. That is why there is a variance process. We are requesting a variance for one septic system in a neighborhood of roughly 200 homes that are already all using septic system. The addition of one more septic system in this neighborhood will in no way be a negative to the neighborhood or the environment. This was confirmed by the EPA environmental study. There are numerous letters on record from neighbors who not only do not object to the approval, but are looking forward to the variance being approved. The splitting of the property is part of our retirement plan. The approval of this variance would not only be a win for us as the property owner, it would also be a big win for the county as well. We recently paid our property taxes. That amount was $4,751.79. If the variance were approved, the overall tax bill for the resulting 3 properties would be in excess of $8,500. The county would basically and almost double its income from the parent lot of land with little to no increase in county responsibilities. That number would only increase as property values rise. A vote against the variance will devalue the property greatly, while at the same time be a disparaging action against the income of the elderly. In our first LUHO hearing, the hardships were laid out very clearly. The property was inherited in this configuration with a nonconformity that is very unique to the neighborhood. Property can't be reparceled, but must be split using the term subdivision due to the lack of road frontage. Again, a unique situation in this neighborhood. If the property had been split in 2 lots by the original owners, the county would not have had an issue with the septic system required when splitting the larger of the 2 lots that is now on the front of the property, thereby allowing all 3 lots to exist, just as we are proposing to accomplish with this variance. This variance would support the 75% future land use element of the county's comprehensive plan. The approval of this variance would provide substantial justice to the current and future owners of these lots, as it would create reasonable use of the land. It would also be a benefit to the neighborhood as a whole and the county. Placing the property in an urban service area while having no intention of providing the stated services to the landowner is a hardship that has been deliberately created by the county. Yet again, another unique hardship. Despite meeting all the criteria required, it was deemed by a single individual that we did not meet the hardships. If we had gotten a different LUHO initially, our request would have been approved. The reason I'm able to say this is we had to change lawyers because our first lawyer, who is in favor of the variance's approval, became one of your LUHOs. Sorry. I'm very confident that if she had heard the case initially, she would have granted the variance. Her name is Ms. Hatley. For one Luho to have such a different opinion from another just goes to show that the spirit of the code is as important as the actual words, since it is so subjective. This is exactly why the LUAB exists, to take this from a one-person's subjective opinion to a collective body with the ability to reason beyond the written code and correct these kinds of injustices created by such codes while they attempt to create a better urban service area. Another thought is this, a little off topic, but I've sat on 6 juries in my life. During that time, I've learned that the jurors have a unique power and responsibility. If they find that a law is immoral, unjust, or being improperly applied, they may vote to find the defendant not guilty through the process known as jury nullification. While this is not a court of law, nor are the members sworn jurors, members of the board sworn jurors, the same concept still applies. Since it is obvious that the law, or in this case the codes, are being improperly applied, the LUAB should vote in favor of this variance request. I had a Zoom meeting with Mr. Dennis Klein, Mr. Clark, and my lawyer with regards to this variance appeal. Towards the end of the meeting, I asked Mr. Klein if he could think of any hardships that would allow this variance to be approved the way that the variance is written. Knowing that I could not use any hardship he spoke of, since, as was stated previously, no new actual evidence may be presented, he spoke candidly with me and said, no, not as the variances, or not as the codes are written. This is proof positive that the code was improperly written or was being improperly applied in this case. As a result, you as members of the boards have an innate responsibility to approve this request. Okay. Once again, we are only asking for a variance for one septic system in an area of the county that does not service and has no plans to service. I would even put forth this offer or suggestion: when you make your motion to approve this request, put a provision in it that if one day in the future the sewage services are made available, that we be mandated to connect immediately. We have no issue with connecting to county services. In fact, we wish they were available now, but they're not. Please do not vote against this variance. Allow my wife and I to divide the property, thereby achieving the 75% urban density goal. Desired by the county, and allow us to complete our retirement plans. We're too old to make up the monetary loss that is going to occur with the denial of this request. Thank you for your time.
Ms. Rodriguez, are there any other persons in the audience that are looking to comment on this?
No one has signed up, sir. Ma'am, sorry.
Mr. Hisney, any comments on the request, please?
No, sir. No, ma'am. Right.
Any member of the board have any questions?
Madam Chair, this is Cameron Clark from the County Attorney. If you have any of the members have any questions about the standard review of the board and what the board's function is, there was obviously part of the presentation related to jury nullification, which is really not what this board's function is. This is an appellate body and not a finder of fact. So if there's any questions from the members regarding standard review of this board, just let me know. Thank you, Madam Chair.
Mr. Clark, I think that would be a good idea to review, please.
Yes, ma'am. So this board's function is to review the application that was presented below to the hearing officer. In a case like this, like a variance, the board is looking at whether procedural due process was followed, which I don't believe there are any allegations in this case that there was improper notice or anything like that. That the essential requirements of law were satisfied, which is essentially that the land development code and state law were not, that those were followed. And finally, and really the main issue that comes up for variance applications is that competent substantial evidence was presented to the hearing officer to grant a variance. So for the granting of a variance, there are the 6 variance criteria. An applicant has to provide competent substantial evidence that each of those 6 are met if the hearing officer finds that such evidence was presented. And for each of the 6 criteria, the hearing officer can then grant the variance. For denial, which is what this one was, the hearing officer is essentially determining that there is not competent substantial evidence for at least one or several of the variance criteria. So the function of this board would be to determine whether competent substantial evidence, read the allegation of the applicant, would be that competent substantial evidence was presented to grant the variance, contrary to the hearing officer's determination. This case was already remanded, so in this instance, in order to, obviously a majority of members can uphold the hearing officer's determination, or a majority could remand it again. I'm not sure I've ever seen a second remand at a LUAB, or a vote of 5 members could overturn the hearing officer's determination. So if there are any questions other than that, please let me know.
Thank you, Mr. Clark. At this time, the board will entertain discussions among the members.
Question of the county attorney's office.
Please.
Okay, this is Brad Cornelius. Mr. Clark, I have 2 quick questions for you, sir. Regarding the supermajority of 5 members, we only have 5 members participating today. Does that mean all 5 of us have to vote to overturn it, or would it be a supermajority of the 5 of us that are here?
It's a supermajority of the board, so you'd have to have 5 members. In past instances, when we've only had a bare quorum of 4 members, if we have a remand case that comes back, it actually has to be continued because there aren't sufficient members present to take all of the options that are available to the board. At a first appeal, the board can either uphold or remand, but at a second appeal of the same case, the board can either uphold, remand, or overturn, but overturning requires a 5th vote.
Okay, thank you, sir. And my second question would be, if this board would want to overturn and approve the variance, does this board have to make a finding on all 6 of the variance criteria on our own? Would that be required?
In general terms, the board is, the hearing officer has made findings on each of the 6 criteria. If in cases where all 6 are found to not be satisfied, and an applicant is essentially appealing the hearing officer's finding on all 6. If only several or 1 were found not to be met by the land use hearing officer, then the appeals board is really only looking at the ones where competent substantial evidence was not found. I mean, obviously, an appellant who has a variance denied, if 4 of the 6 criteria were found to be met, the appellant isn't challenging those 4, because on those 4, the appellant got what they were asking for. But really, then at issue are only instances where the hearing officer found that there was not competent substantial evidence. And Ms. Rodriguez could, if it benefits the board, identify in the record which criteria were found not to be met by the hearing officer.
Okay, so in this case, the land use hearing officer did not found against in all 6 criteria. So we would have to address all 6.
Yeah, in which case, then what happens is the board would actually have to find individually that competent substantial evidence was presented to meet all 6 criteria, contrary to the finding of the hearing officer.
Okay, thank you, sir. I appreciate that.
Yes,
Mr. Evans.
yes. Looking at the hearing officer's decision, it looks like there were 4 criteria that they found that were not satisfied, 1, 2, 4, and 6.
Sure, I can answer, or should?
I'm confirming that as well.
Yeah, from the initial remand, the four of us were here for the initial remand. Those are the items that were remanded back to the land use hearing officer. The other ones that were not remanded back to her. So that the total finding was all 6.
Yeah, this is,
Campbell?
thank you. This is Jerry Campbell. I'm just curious, this question is for Mr. Clark. Is it possible for the board to ask for a different LUHO to hear this? Or is there some statute of time which the appellate could come back at a later date and ask for a variance again, in which case they would probably get another LUHO? So I guess that's actually 2 questions. One, can the board ask that this be remanded somehow to a new LUHO? Or is the only way that a new LUHO would hear this is if there is some statute that allows a period of time to pass in which the appellate then can come back and have the whole thing reheard, probably with a different LUHO?
So sir, I'd have to answer in the negative to both of your questions, which is unusual in this instance because of the circumstances of this particular variance application. Not this application in particular, rather the code provision that the variance is being applied for. First, this board doesn't have the ability to request a different hearing officer. The hearing officers, the hearing officer who gets a case is really just determined by what date that the original hearing is set. And so our hearing officers alternate hearings. So if, depending on what date the original LUHO hearing was set, the applicant gets that hearing officer. When it's remanded, it is routinely remanded to the same hearing officer, because if it goes to a different hearing officer, basically the whole case has to be presented from scratch. And also, it's not fair to hold one hearing officer to the determinations of another hearing officer. So remands always go back to the same hearing officer. There's no provision in the code that allows the board to remand it to a different hearing officer because the board is really looking solely at what was presented to the hearing officer and seeing if it satisfies the competent substantial evidence standard, which is just that a reasonable person could reach a conclusion based on the evidence provided. As to your second question, the reason the answer to that, in general terms, if a variance is denied, an applicant can reapply like a year later. But in this instance, the Board of County Commissioners amended the Land Development Code to remove certain criteria from it regarding allowable water and sewer. Actually, Mr. Hisner may have to refresh me on this. They removed a provision, I believe, that allows for well connections within the urban service area, which specifically addresses this area of the code. It had been a provision for a long time, but the board removed it within the last year, I believe, so that this is an application that when it came in, the code standard that it was applying under was different than it is now. So it's before you now essentially as a grandfathered application because the application was submitted before the effectiveness of the board changed. But obviously, if this application was to be withdrawn or denied at this time, the code in the future does not look the same as it did when this application initially came in. I hope that explains, that answers the question you asked.
Yes, it did. Thank you.
Any other board member have any questions or comments? There being none, I would entertain a motion to approve the LUHO's findings.
Do I get a rebuttal?
Motion to uphold those finding of denial. Oh, Brad Cornelius. Sorry about that. This is Brad Cornelius. I make a motion to uphold the LUHO's findings of denial.
Is there a second? I will second it, Ricky Bauman, Chair. Is there any discussion on the motion? Mr. Campbell?
Yeah, I'm conflicted on this because I think the intent of limiting septic tanks in the urban service area was for groundwater issues. And apparently the size of the lot, as I understand it, they wanted no more than one septic tank per acre. And if he added a third septic tank to the size of the lot, as I understand it, he would meet that criteria. But I understand that there are other considerations, and that's not the sole consideration in this case. Very, very difficult, no easy one on this one.
Any other board? Mr. Evans?
Yes, I'd also like to say, the intent of the urban service area is to connect to county utilities. And certainly when you have larger development, it's more economically feasible to run a line extension. It seems that in this case, we have an individual homeowner that is being saddled with a burden that they really can't afford. And they're stuck in a situation where they really can't feasibly connect to the sewer, and their only recourse would be to apply for a variance, which I would be in favor of that.
Well, unfortunately, although we might have sympathy on a personal basis, the lot already has 2 homes on it. That is legal according to our county records. The only question here would be, would we be able to add a third lot with the existing septic, with the existing wells? And that's the basis on which the land use hearing officer denied the application. And it's not a question of whether, well, let me do it another way. The hardship is not the lack of ability to split off another piece and build another home and make money. The only hardship in the case could be the proximity to the county pipeline, pipe system. But does that justify us overturning the land use hearing officer's decision? And I personally don't think so. I don't see anything so egregious or so wrong, or I don't, having read it exhaustively, and we heard this last time, although we might say, gee, it's a big lot, it might be nice to do that, and gee, at virtually no cost, you gain a nice windfall, great, no problem. But unfortunately, the lot is perpendicular to the road and not along the road, and that gives you a different possibility when you have that. But it's a long plot, and however this runs topographically, we have no idea. We don't know if it runs downhill to the road, uphill to the road, and that's not for us to decide. That's for the specialists here in the buildings department and EPA and all that to decide, well, is this feasible or not? My personal opinion is they're saying no, and I don't have any basis on which to say, oh no, you're wrong. I don't see where any of the criteria that they applied, I can say, that's not right. It's just not right, and I don't see that. If anybody here does, please, if you see any errors of fact, Mr. Evans.
Yeah, they are meeting all of the other technical requirements of the code. The only thing that they're not meeting is connection to public utilities, which is really no fault of their own. I would argue that they are uniquely situated in an area where this puts them in a position of not being able to comply with the code because of the location of the property, that it is not located within a reasonable distance of connecting to the sewer line, but that they are within the urban service area, which requires that. So they're stuck in a catch-22 that they don't have the ability to comply with. They'd, I'm sure, love to comply with the code if it were possible. But I'd argue that that's the purpose of the variance process.
Love you, bye-bye.
And that's true, but you'll find over time, as you're at these meetings, there's a lot of requests for similar type of things, a third septic on a lot, and the criteria allows for 2. It doesn't allow for 3 on a normal basis. You've got to do something else to make that work. Whether it's not for us to figure, is it water pollution? Is it the aquifer, the drain fields? That's for specialists to figure out.
You've already approved it.
Madam Chair, just to kind of add a little bit to what you say there, what I find very compelling for the denial is just the fact that, yes, they're in a difficult situation, but as a land use hearing officer stated in her findings, they're not unique and different. There are many properties in this area that have the same limitation in the urban service area, unable to connect, and they have the exact same limitations this property owner does. So generally for a variance, a property really needs to be unique and different and not a commonly shared problem with other properties. When you run into an issue that's commonly shared by many other properties, that's sometimes a signal to a local government, you need to change your code. But I don't see this property being restricted any more than anybody else that's in that same situation in this part of Hillsborough County.
Is there any more discussion? Then I will call a vote on the motion. I, Ricky Bauman, will vote to uphold the land use hearing officer's decision. Mr. Cornelius?
Where's my rebuttal?
Oh, excuse me. Thank you, Mr. Clark. The appellant has 5 minutes of rebuttal. Please proceed.
Now?
Well,
All right.
board members, can I interject? So nobody else has presented testimony. The appellant has presented his issue. In general terms, the appellant does not get to rebut the board. Oftentimes we have interveners or we have other parties who have spoken for or against something the appellant is bringing forward, but the appellant is generally not afforded an opportunity to rebut the board members.
Yeah, that's what I thought, Mr. Clark, but hearing the interjection, it was like, okay, am I missing something? Thank you. So I will call for... Yes?
Nothing else, madam.
Then how come we've always had a rebuttal, even though there was never anyone that spoke against it? Every meeting, we have had a rebuttal, even though no one has ever spoken against it.
Sir, at the land use hearing officer hearing, the applicant is allowed to offer a final comment or comments after staff or any other third parties present their presentations.
I agree with what you've just said, but I'll also state this is the third time I've been in front of the LUAB, and both previous times in front of the LUAB, there has been a rebuttal time without any negative against me. The only negative against me I've ever gotten was from the county. Even the Environmental Protection Agency approved what we wanted to do.
Thank you, sir.
We have a motion on the floor to uphold the decision of the land use hearing officer. I, Ricky Bauman, Chair, approve that motion. Mr. Vice Chair?
I approve the motion.
Mr. Evans? Mr. Campbell?
I approve.
Mr. Schwartz?
I do not approve.
All right, Ms. Rodriguez, note that the vote is 3 to uphold and 2 against. The motion passes to uphold the decision of the Land Use Appeals Board. Land Use Hearing Officer. Please call the next case.
Sleep well, ladies and gentlemen.
Next case is on page 4, item 3A, appeal APP 21-1079, petition file number variance 21-0586. The appellant is Stephen and Patrick Ray. The representative is Mark Bentley, Esquire. The property owners are Jose, David, and Irene Santana de Jesus. The property owners, and that is for the 8704 Hyder Joe Lane. The property owners are Richard E. April, Jesse, and Matthew Hayter, and they reside at 8710 Hyder Joe Lane. And the petition request is to appeal the decision of the land use hearing officer who approved a variance for a 10-foot reduction in the required easement width to allow a 20-foot wide easement to serve the subject property. The location is 8704 and 8710 Hyder Joe Lane. The property size is 1.26 acres more or less. The existing zoning is RSC-6, future land use CMU-12, service area urban, community planning area town and country. The date of the land use hearing officer hearing was May 24th, 2021.
Ms. Rodriguez, could you please swear in the person giving testimony?
He's already been sworn in. Just please state your name and address for the record. Up there.
My name is Mark Bentley, 401 East Jackson Street, Tampa 33602, and I represent the appellants. Before
Please
I get
proceed,
started,
Mr. Bentley.
I'm sorry, sir. Ma'am, I'm sorry.
Please proceed, Mr. Bentley.
Okay. Before I do, and before you start the meter running on me, I've got some exhibits that are part of the record, but in an organized fashion that are being handed out to you, hopefully right now.
Board members, this is Cameron Clark. Mr. Bentley, can you attest to the fact that what's being presented to the members is within the record that was presented to the hearing officer?
That I've represented who?
Can you represent that the documents that you were handing out are the same documents that were reviewed by the hearing officer?
Yeah, Cameron, I want to up front tell the board this is that number one, the reason I gave you these composite exhibits, they're all in the record, but I went on optics and I saw that the county had copied them in kind of a disorganized, haphazard fashion. So I wanted to logically go through them and kind of give you some of the key ones. Secondarily, anything I say is in the record. And third, and most importantly, board members, is I think I had 18 pages of testimony in the transcript. And at the conclusion of the case, none of what I said was refuted. None of the testimony or evidence, but for the applicant had contested a couple of things I said about life safety access through the easement. And right up front, I mean, this is a case that's been going on for quite a while, and there's some somewhat complex issues. And if I could have additional time, I mean, I'll try and get through it as quickly as I can. And I represent that none of it's going to be irrelevant, duplicative, and it will ensure due process for our client. And if the board's inclined to do that, I have no problem if the opposition has the same amount of time. So. Is this working by any chance?
We hear you, Mr. Bentley. Please proceed.
Okay. I'm just trying to get organized here. What you have here is just you have the lay of the land. You have the easement, 20-foot easement recorded in 1996 for ingress and egress only to one lot. This is represented as two lots. The easement was granted to one lot. So what you see here is what I'm pointing to, a house that was built in 1959 owned by one of the applicants, De Jesus. The other home, I think, is under new ownership, but at the time, the applicant was the Hyder family, I'll call them that. And based on the testimony in the record, and you can look at page 112, the zoning for the subject property is RSC 6, and there's a triplex on the property, which would constitute a zoning violation. So you're going to hear through the evidence, and I'll point you in the right direction, is that the applicant had requested for ingress and egress, a reduction from the required 30 feet to 20 feet for 2 units, not 2 lots. And that's an important distinction I'll get into. The code section she cited was a variance request to allow for 2 units. but based on information provided by the property owner and testimony of our client, there's a triplex on this property and a single family here. So that would be in violation of that section, the variance section, and also exceeds the applicant's request, obviously. And the hearing officer, I'll show you too, she was a little bit confused in her findings of fact and conclusions of law as to how many units were actually out there. Also like to point out that the applicant's properties were subject to code enforcement proceedings for violating the code as the owner had split the lot and misrepresented the easement met the required 30 feet to induce the county into splitting the lot in the year 2000. And then subsequently, about a year later, to issue a building permit. However, the code enforcement documents were not filed as required by the county's variance application. The actual application, there's a box that says, are you under violation? It says, if so, provide a copy of the notice of violation. That was never provided to the county. So the application was incomplete and missing a material component and should have never actually been processed. So consequently, what happened here is they went through this entire hearing, and the only reason they're at the hearing is because they're under code enforcement. And first, the applicant never mentioned the violation in her presentation. The staff never mentioned the violation in staff report or any of their testimony. And it never shows up in any findings of fact or conclusions of law that both properties were under violation. So it's kind of strange, as that's the only reason they had applied for the variance. What I'd like to do now is show you Exhibit 1, what I mentioned. I highlighted, look at C. That's the variance request to serve 2 or 3 dwelling units. A totally different section of the code, which the applicant is for 2 or 3 dwelling units. There's another section that speaks to lots above that, but I just want to make clear that they had requested the units. If we go to tab 9, I think this is important, and it kind of reinforces what I just told the board, is this is a printout for the lot that I just mentioned, on the western lot that has a triplex on it. And as you can see, Hillsborough County property appraiser characterizes the use of the property as multifamily residential, less than 10 units. And if you go to the next page, at the top, it says building information. It says duplex, triplex, and quadruplex. My client testified at the last hearing that it was his impression that it was a triplex. We had mentioned that in our testimony. It was never refuted. So the easement is actually not for 2 units as represented in the application, but for 4 units. And this finding is not made by the LUHO, which is a fundamental error, and as she ignored the evidence and also contradicted the applicant's application. The LUHO then misstates the request on page 1 of her order, stating that the request is for a variance to easement with requirements to serve 2 existing lots on property zoned RSC 6. Here again, the code section that she filed under is to allow for 2 or more units. There's a major distinction between a lot and a unit. One of these lots, 8710 Hyder Lane, owned by the Hyder family at that point in time, has, for unrefuted evidence, 3 units, and the eastern lot has 1. So we're dealing with 4. The code only allows for up to 3 units to be on a in the urban service area to be on an easement. And here again, both these properties are zoned RSC 6, which allow 1 single family unit. So the property to the west has 3 units, which would require a rezoning to make it consistent with the land development code. In the findings of fact, there's only 2 units, which is wrong and contradicts the applicant's request and contradicts the testimony. So I would think that the application can't be accepted until the 1 single family with the duplex is rezoned to make it legal. I think if the county would have known right up front when the applicant made the application that they were dealing with an excess of one unit on a property zone single family, that I'm not sure if they would accept the application or make them resolve that prior to filing. Then if we go to exhibit number 5, this is important to this case, as the owner at the time was the applicant's father. At the time the lot was split, was the applicant's father, who filed false documents with the county to induce it to do 2 things. Number 1, allow the parcel split, called parcel certification. And number 2, allow for a new home for a single family. That's the permit that was issued, which now we know is a triplex. So if you look at number 5 on my handout, what you'll see is a building permit application. Excuse me, yeah, the attachment to a building permit application. And as you can see, everything's drawn in AutoCAD on this site plan that was submitted by Mr. Hyder to the county to induce it to issue the permit. But you'll see where I'm pointing here, and I highlighted that for the board. Someone wrote in a 30-foot easement when it was actually 20. And you can see in terms of the scale and all the other numbers on this plan here that was written in, it's not to scale. So that was filed with the county. As a requirement was you had to have a 30-foot easement to get the building permit. And then if we could go back to 4, I want to show this to the board. This is a parcel certification letter issued by the county in 2000. And what's interesting here is they allowed the split. Okay, and here again, the property zone single family. And then attached to the letter, which the county required to be recorded, public records, as you can see, the legal description that was prepared by the Mr. Hyder, the applicant, as he indicates that the easement width is 30 feet when the 1996 easement is 20 feet. Notably, the easement was not provided to Hillsborough County, and that's based on a response we received to our public records request. So with that in mind, let's look at the criterion, because it's our position that the variance did not meet 2 of the criterion, that Lujo had it wrong. There wasn't substantial competent evidence to support that. Criterion number 5 states, explain how this situation sought to be relieved by the variance does not result from 1, an illegal act, or 2, result from the actions of the applicant. So it does not result from A or B. These are 2 distinct provisions in the criterion. An illegal act could be an illegal act by anyone, not necessarily the applicant, or number 2, results from the actions of the applicant. The variance was being sought to resolve a code enforcement action that it took the county 21 years to address. But here again, you'd never know that because there was nothing in the record concerning code enforcement. And that never showed up in the findings of fact or conclusions of law. The easement granted from our client to the grantee in 1996 was for 20 feet for ingress and egress only, for one lot that included a home built in 1959, now owned by one of the applicants, De Jesus. Without discussing who owned the lot, with our client, the Hyder split the lot in 2 in 2000. And here again, the split was illegal. So I guess from a legal standpoint, you'd say it's void ab initio if the county relied on misrepresentations in issuing the certification. And that's a result of providing the county with incorrect legal description. So then tab 4, the county approves the certification, says you must record in the public records. If you look at that legal attach, as I mentioned, they have 30 feet when it's actually 20 feet. So in terms of criteria number 5, the actions were the result, illegal acts of an owner at that point in time. And then what happened, and this is tab 7, then in 2009, to make things even more complicated, if you look at tab 7, and I'm getting to that. If you look at tab 7, this involves actually the applicant, as you can see where I highlighted. Here again, there's a recorded 20-foot ingress and egress easement. And in this document, order determining homestead status of real property, there's a conveyance to Hillsborough County for a perpetual exclusive utility easement, and I've highlighted that in the bottom of the page. What that means in legalese is it's perpetual and it's exclusive. It can only be used by Hillsborough County for utilities. So now we've gone from 20 feet down to 15 feet because you can't use that 5 feet. So the actual application to Hillsborough County for the variance should have been from 30 feet to 15 feet. Now I can question the legality of them unilaterally granting an easement that they didn't have legal right to do, but I'm saying that's just what occurred. That was in the record and it was never mentioned by the LUHO. So because of the illegal acts and the actions of the owner granting a 5-foot perpetual exclusive easement, reducing the easement to 15 feet, she represented she had 20 feet in her application. The application should have been denied. Nothing I'm telling you ended up in the findings of fact. And you can see pages 11 to 12 of the LUHO's order. The LUHO actually ignored everything we submitted into the record, all 15 exhibits and all of our testimony. So the LUHO analysis is incorrect as she ignores findings of fact and misapplies number 5. And what the LUHO did basically and said, even though the code says illegal actions of an owner, the LUHO's position was, hey, the applicant didn't do it, someone else did it, so I'm not really going to hold that against them. But the code doesn't read that way. It says illegal act of owner or actions of the applicant. Then criteria number 3, substantial interference with the rights of others. Now we have 4 units instead of the 1 unit that related to the original granting of the easement on the property. So this increase from 1 to 4 units will create more traffic, noise, dust, life safety concerns, maintenance issues, et cetera. It will interfere with the proposed residential use of the property and our clients' use and enjoyment of their property. So there is substantial interference based on substantial competent evidence that was in the record that the LUHO ignored. I'd like to talk about my appeal. I'm short on time here and I appreciate, what you guys are doing. Give me some additional time. But if you go to my actual appeal on page 1 in paragraph 2, as I mentioned, the 5 feet that was granted, I don't need to get into that. We can go down to paragraph 3 of my appeal. It's called written statement. And it says the appellant is now adversely impacted by multiple users of its property, which was never authorized, and the fact that emergency service vehicles, fire trucks, et cetera, cannot maneuver down the easement, which is now utilized by multiple users instead of the intended one single family home. The overburdening of the easement has created safety concerns, including increased traffic, noise, and access to the appellant's property and cell tower on appellant's property. Also, as mentioned, the applicant has unlawfully conveyed the 5 feet of the 20-foot easement. Importantly, the applicant failed to include in its application the required notices of violation issued by Hillsborough County Code Enforcement, nor did either the county or the applicant mention the violations at the hearing. And that was the sole reason for that hearing. Therefore, the application was incomplete and should have never been received by the county nor acted upon by the LUHO. And let me get this straight. The reason they were under code enforcement was because of the illegal lot split, which put 2 units on a 20-foot easement. Okay? And so that was the genesis of that, the original act by the owner, and then the misrepresentation that induced the county to issue a building permit where they kind of handwritten in 30-foot when it was in actuality 20 feet. The decision of the LUHO must be reversed because of incomplete application, failure to identify material findings of fact necessary on appeal, failure to properly apply the facts to the variance of criteria, failure to have the code violations in the record, and deficient conclusions of law. The following are some examples of insufficient factual support, errors and omissions of material facts, due process violations, and insufficient conclusions of law by the LUHO, which warrant reversal of the LUHO's decision. One, the LUHO failed to state that the applicants were in violation of the county's land development code, which was material fact for the case and which was the reason for the variance request. Number two, the county failed to include notices of violation in the record at the hearing, although required by the code in their procedures manual. Number three, the LUHO failed to indicate that that unrefuted testimony was the applicant's property was being utilized for an illegal triplex when that property is restricted to one conventional single-family home under the LDC. Accordingly, the LUHO's decision provided a substandard easement to an illegal use. This is no different than granting a variance to an industrial use in a residential zoning district. Number four, the LUHO failed to indicate the lot split necessitating the 30-foot easement was a result of illegal action by a property owner in violation of criteria 5, who was the father at that point in time of the applicant, who intentionally provided inaccurate information to the county. Number five, the LUHO failed to indicate existing easement was not 20 feet, but actually 15 feet after the applicant conveyed a 5-foot perpetual exclusive utility easement, and I gave that instrument to the hearing officer for her consideration, and she ignored it. Number six, the LUHO failed to indicate property owner, the father of the applicant and owner at that time, provided false information to the county to induce issuance of a building permit and parcel certification. Number seven, the LUHO failed to indicate the applicant did not rebut assertion that the property of one applicant was used for a triplex. When we testified as to the triplex on rebuttal, the applicant was completely silent on that. Number nine, the LUHO misstated each property owner owned by applicant was developed with one single family residential dwelling unit portfolio, and that's in her findings of fact, which is incorrect. Number 10, the LUHO misstated that the variance did not result from an illegal act or action of the property owner, which we know is incorrect, when the evidence confirms illegal actions of the property owner, father of the applicant, induced the county to approve the parcel certification on lot split and approve a building permit of one per unit that is now being utilized as a triplex in violation of the LDC. And let me note, board members, is that when I brought this to the attention of the county, I initiated the code enforcement action, so they agreed with me concerning the improper parcel certification and proper issuance of the building permit. That's why they were under violation. Number 11, the LUHO failed to indicate testimony that emergency vehicles cannot access applicants' properties. Our clients testified to that. Number 12, the LUHO improperly sought a legal opinion from the county attorney who was representing a party, Hillsborough County, and not the LUHO, instead of seeking legal advice from an independent counsel for the LDC, therefore denying due process and prejudicing our client's position. Number 13, the LUHO failed to indicate that the applicant admitted in the application that the paperwork to Hillsborough County for parcel division misstated actual width of the easement. So even by their own admission, the applicant says that they misstated the actual width of the easement. Number 14, the LUHO failed to make any required conclusions of law other than mention in passing LDC section 11.04.02. Number 15, county failed to provide the LUHO with code enforcement notices of violation. And the only way they're in the record, and you might have them at this point in time, is that I petitioned to the Development Services or Land Development Department. Excuse me, I'm not sure what the proper title is after the hearing, I said, by the way, that these documents never made it in, and that was the sole reason for the application. So ultimately, they got into the record, but after the hearing. Number 17.
Mr. Bentley, you've gone over time. Can we wrap this up in another minute, please? We've given you more than extra time. Thank you.
No, I am. I appreciate it. I'm sorry. Okay. Number 17, the transcript provided by the county deletes relevant testimony of the easement grantor, Stephen Ray, at least the transcript we have, which is pages 111 to 112, in which the grantor testified that only one house was to use the easement and that the easement is now overburdened. Number 18, the LUHO failed to indicate the variance is not in harmony with the LDC. It allows access to an illegal use not authorized by the applicable RSC single-family zoning district. 19, Lujo failed to indicate granting of the variance would substantially interfere with the appellant as it overburdens the easement, resulting in additional traffic noise and impairs the ability of the appellant to utilize their property, as the easement is non-exclusive and also provides access to a cell tower on appellant's property. Number 20, Lujo, there's no competent evidence to substantiate or support meeting criteria number 5 about the illegal acts. 21 did not meet criteria number 3, as 3 units on easement will substantially interfere with our client's rights to reasonable use and enjoyment of its property. So that's about it. I mean, I could go on. I appreciate all the additional time you've provided me. If you have any questions, I'll certainly attempt to answer them. Thanks a lot.
Mr. Bentley, I have one particular question. Could you put that map back up again, please?
Sure.
Okay, if I have it correctly, your client's property is the odd-shaped parcel on the right of the red?
My client's property is these properties here, and here. And this is the northern property line. There's the church right where I'm pointing essentially. And then the easement, the easement goes from the easement goes from Sheldon Road right here at this corner of Hyder Lane, and it goes easterly 20 feet to this property, which is the one with the triplex. And then this is the lot. This was the lot split here that I would mention to you. And here's the original home from 1959 that the Hyders used to live in, that they sold it to the De Jesus family a few years ago.
So what is the actual issue that I'm not getting as to why it cannot be a 30-foot easement? If there's nothing there, if this is empty, except for a possible shed that I see on this diagram, what is the problem with the 30-foot easement as opposed to the 20? I'm not getting it. I understand there were irregularities and all that, and they said this and they said that.
Okay.
That happens all the time, unfortunately, in real estate. And the county catching up 20 years later is neither the county's fault nor responsibility. It is what it is. But what is this? What is the problem here with that 30-foot easement and asking for the reduction?
There's several problems. Number one, the original agreement between the parties who are neighbors is that there would be an easement for one single-family home across my client's property. Number two, it'd be 20 feet, which is adequate for one single-family home. Okay. Number three, our client uses that easement. Now it's overburdened. Instead of one home, there's 4 or 5, at least 4. Number 4, the client rezoned the property, which I handled a couple of years ago, and that property, is targeted or proposed for a residential use on that property. Probably kind of like townhomes, multifamily property.
All right, so, but let me ask you a question, and as an attorney, you would certainly know this. Was that triplex visible? Were these homes visible at the time of the purchase or the time of the split or whenever this went on?
No, our client doesn't go over and inspect, but occasionally they would go back there, and ultimately they determined that there was a triplex. The permit I gave you from Hillsborough County was for one single family unit, and it's been a kind of, I guess, a slow evolution, and actually what's kind of interesting now is that, well, I'd be getting into new evidence, and I can't, I can't do that.
No,
But so anyhow, what you have here is a 20-foot easement, okay, and now you have all of these units, and especially on the one property, that easement or variance should have never been granted based on the testimony. And I showed you from the property appraiser, it's not a single-family home; it's a zoning violation sitting on that lot. Okay, so everything was skewed or misrepresented, even in this application, that there were only going to be 2 units using the 20 feet. And that's what the staff based its analysis on. All right. So now they're overburdening the use of that property. It interferes with my client's use of the property as we speak. And certainly when the client intends to redevelop the property with single family use on that property. Okay. So it's not no harm, no foul. What's an additional 10 feet? You know, my client has property rights here, and someone kind of did an end run around a lot of these regulations to the detriment of my client. And that's fundamentally unfair. And it violates, you know, apparently many of the county's land development codes. And these approvals they got from a lawyer standpoint, and I don't know if you have any lawyers on the board, but when you induce someone to issue a permit under Florida law, okay, by presenting false or misinformation or misrepresentations, it's as if that permit was never issued. It's called void ab initio. So the correct thing to happen right now is to go back and get a proper parcel certification and lot split, okay, and then get like another permit, or I guess you'd have to rezone the property from single family to allow for a triplex on that property. That's the proper thing to do right now, because I don't think those permits are even valid.
Who's the owner of the triplex?
I think it's on the day of the hearing. It was, I think the Hyder family. I'll just call them that, and I don't want to disrespect them. I think
that's not your client. That's what I want to. That's not your client.
No. Okay. My client is Stephen and Patrick Ray, who own they were the grantors of the easement. But to answer your question, the property since the day of the hearing, I think on May 4th, has maybe sold. It's sold once, maybe twice at this point in time. Okay.
Okay. Thank you.
Thank you.
Does any other board member have any questions of Mr. Bentley? Thank you, Mr. Bentley.
Thanks a lot.
Rodriguez, are there any other witnesses to testify?
Yes, if you have signed in, please come forward. You did take the oath, am I correct?
I did take the oath. Thank you very much.
Please state your name and address for the record.
Good afternoon. Isabel Albert with Half Associates, 1000 North Ashley Drive, Suite 900. And I'm here representing the new property owner that's being affected by this.
Please proceed, Ms. Albert.
I'm sorry?
Please proceed.
Thank you.
Tom, since they weren't a party of record, can they speak?
Cameron, would you please address Mark's question?
Were you not at the?
He wasn't away from. He wasn't at the microphone. I couldn't hear his question.
Hey, Cameron. Hey, Mark, how you doing? Isabel's client has purchased the property subsequent to the hearing, so they never participated in any of the proceedings. My question was, are they a party to the appeal here as a new owner, relatively new owner? I didn't mean to interrupt you, Isabel. I just want to get that straight.
So to be clear, you're talking about the representative of an owner who did not participate in any way before the hearing officer?
A new property owner, okay, subsequent to the hearing. That property was sold, the property at issue here. So do they have standing to participate in the proceeding?
The question I'm asking is, this new owner, did they participate in any way before the hearing officer?
No.
So board members, pursuant to section 100502 of the Land Development Code, which is subsection B of that section, standing to appeal, the following shall have standing to appeal of a decision of the hearing officer or to intervene in an appeal that has been filed pursuant to this section. One is an applicant who is adversely affected by the hearing officer's decision. In this instance, that would be the applicant who filed for the variance that Mr. Bentley is objecting to. Second is any person or entity who was present at the hearing officer hearing and presented either oral testimony or documentary evidence, or who submitted documentary evidence themselves or by proxy prior to or during the land use hearing officer hearing, and that is adversely affected. So if it is correct that this new property owner was not present to submit any sort of verbal or written testimony before the hearing officer hearing or at the hearing officer hearing, then they wouldn't have standing to participate in this case. I'm actually not quite sure how they would have been noticed as to the case, but because only parties of record are generally noticed of LUAB appeals.
Hearing that, Ms. Rodriguez, are there any other persons to testify?
Is there anyone that was at the original Lujo hearing here to testify?
Madam Chair, may I impose a question very briefly?
So
Can Ms. Albert,
the
can
new
Ms. Albert
property
state
owner,
in the record whether or not her client is a party of record under the code?
Cameron, the new property owner was not present prior to the hearing. He has purchased the property since then, but he's being severely adversely affected by this hearing and has asked me to represent him. I think that the new property owner should have a right to speak on a matter that's being affected to his personal property.
You know, I appreciate that concern, Isabel. I do. I think my problem is just that as the code is drafted, it does not this is an appellate proceeding, and so the record is locked and the parties of record are locked in. For instance, if the case was remanded, there would be a new hearing and new parties of record could potentially enter evidence. But at this point, this is an appellate proceeding, and so both the record and the parties are locked in.
So my client was notice of this appeal. Does that make him a party of record?
I would say that your client, if they did not participate in any way, shape, or form at the original land use hearing officer hearing, either in person or through submitting documentary evidence, they should not have been noticed. Were they noticed by name, or did mail for somebody else just come to their address? I can't imagine it was by name if they didn't participate in the hearing.
So I'm sort of kind of floored by this. So he has no say. Yeah, he's saying
the new property owner is not a party of record.
Okay, Cameron. So what do you recommend that we do then?
I can't make a recommendation to a private party.
So are you saying, too bad, you cannot speak and we just have to take the word of the appellant?
Only parties of record, only the applicant, the original applicant, and parties of record are able to speak at this proceeding. I mean, think of it from this context. If the LUHO hears a case and renders a decision and it never gets appealed, and then a new owner comes in, that new owner is going to be affected by what the hearing officer did. This appeal has lengthened the process by essentially delaying the effectiveness of the hearing officer's decision if it was to be upheld. But essentially, a new owner can't undo the decision of a hearing officer that was rendered prior to their living there. So no, I would say under the code, they don't have a right to participate. Again, if this was to be remanded based on the record, then the hearing would be renoticed and there would be potentially new opportunity to participate. But without that, once the hearing officer's decision is rendered, subsequent property owners who did not participate aren't parties of record.
Okay. So the only way that we can speak is if we request to be remanded.
I would actually say you can't request anything because your client's not a party of record. If it was to be remanded, then provided that your client lives within the mailing radius, they would receive notice of the new LUHO hearing.
Okay. So and sorry, this is procedural, but if somehow the board decides to remand us, then we would become party of record just by receiving a notice, correct?
No, for a LUHO, for a ZHM, for rezoning, yes. If you want to be a party of record for the LUHO, you actually have to participate in the process. So if they receive a notice, they would have to then either appear at the hearing and speak, or they would have to submit documentary evidence through the usual channels, or have someone else present evidence for them. But mailing wouldn't be enough. They'd actually have to participate.
No, right, but when you remand, I guess you can receiving the letter, then we would show up and speak. Yeah, okay.
And I'm sorry, let me board members. I know Miss Albert. She worked for the county before, and I'm sorry to have sort of inside baseball conversation like this in front of the board. I can certainly communicate with Miss Albert after the fact and advise her how they can participate if the case was to be remanded.
Yeah, sorry about that.
Mr. Clark, I have a question for you about the legal description and the ramifications thereof. The legal description has a 30-foot easement. And let's just say, for the sake of argument, that it's just not 30 feet. It's smaller, it's larger, but it doesn't meet the code. That does not hold the county to any particular standard other than exactly what the code is. Am I correct?
So I'm sorry, I want to make sure I've got that straight in my head, Madam Chair. Could you restate that? You're saying if there's a finding of fact in the record that is in error.
So if the code, the thing says 30 feet, let's say for the sake of argument that in reality it's 20, it's 40, it's not correct. That does not obviate the owners of ensuring that that right of way or easement is correct if it comes to the county's attention.
Well, speaking to the obligations of the owner, it's hard to say. I think if there's something in the staff report or something that was in the application that is factually inaccurate, the variance decision would be based on incorrect information. I'm not speaking to whether or not anything from an applicant was entered into the record, like deliberately or accidentally. I don't think that matters. I'm just, I don't know if you're saying if a decision came to the board and it had factually inaccurate, some sort of inconsistency in the record between what's in the documentation versus maybe even inconsistency. One part of the document says an easement is this wide and another part says it's a different width. I think you could probably remand something in order to clear up the record, if that's the question that you're asking.
Actually, it's a little different. If the legal description says 30 feet, but in actuality, it's not. The appellate is asking for the reduction, even though the code requires 30 for various reasons. Does that void out the process and put it back to square one because it's a moot thing? If it says it's 30 feet, you've already got to have 30 feet before you request a variance?
In the circumstance you're describing, what is you said in actuality it's not. Are you saying, are you describing something that there's a different?
That's the appellant. That's the testimony of the appellant that in actuality, the easement is not what it says in the legal documents, and that's why they're asking for a variance.
So the appellant is stating that something in the record, that a fact entered into the record that the hearing officer's decision was based upon is inaccurate.
Correct.
And can you remand on the basis of Mr. Bentley's statement that there is an error in the record? Is that your question?
Pretty much, yes. Well, what do we
Okay.
do with it? Yeah.
So the issue regarding competent substantial evidence is you could have two, well, not you, but I'm sorry, a hearing officer can have two options presented to them. And let's say an applicant presents competent substantial evidence for what they want. An opponent could then step up and present competent substantial evidence to something that's contrary to that. The hearing officer really has to essentially make a decision between the evidence that's provided. A decision by a hearing officer based on competent substantial evidence is sustainable, even if there is also competent substantial evidence to some other effect. Essentially, the hearing officer has to, it's part of the decision-making process of the hearing officers to take that decision, to weigh that evidence. The key issue for the variance determination is the presence of competent substantial evidence that supports each of the 6 variance criteria. And so therefore, in regards to the appeal of a variance, the board is looking at the absence. Is in fact there not competent substantial evidence to support each of the 6 criteria? The fact, if the board looks at the evidence and says, yes, there was competent substantial to support these 6, however, the opponent also presented some good evidence to the contrary, the board can uphold the hearing's decision if they determine that there is evidence in the record to support the decision, even if there was also evidence that potentially contradicts it. I hope that didn't muddy the waters.
Thank you, Mr. Kolak. No, actually, that's quite clear. Appreciate that. Do any of the other board members have any questions of Mr. Bentley, Mr. Clark, or any staff member?
I have one question. Can you hear me?
Yes, Mr. Schwartz, go ahead.
It says that the legal description shows a 30-foot easement. Is that correct?
That's what I see, yes.
And then it's been stated that that's incorrect. My question is, what evidence do you have that shows that legal description is incorrect?
We personally do not. That is the applicant. And that's what they're requesting. They're requesting reduction of the easement from what we would consider code required 30 feet to 20 feet.
I understand. Thank you.
Mr. Campbell?
Yeah, I had a couple questions. So if you have a 20-foot easement and you give 5 feet of that easement for utility purposes, does an easement have to be paved? Because I'm assuming that a utility easement cannot be paved, cannot have permanent structures on it. So it sounds to me like they took a 20-foot easement, carved off 5 feet of it for utilities, which cannot be paved, and maybe an easement doesn't have to be paved, but it sounds like what they're left with is truly a 15-foot easement, because if the utilities folks were to get in there and do some digging, you would be left with a 15-foot easement on the side to access 2 structures. And the second one, it sounds like the property appraiser went out there and said it's anywhere from 2 to 4 units in that single structure. And I'm looking at page 20 of the backup material that we got. And this is Mr. Hisney. And he says, Mr. Hisney pointed out that the single-family home is permitted to have an attached accessory dwelling unit subject to the requirements of the LDC. He stated he could not say whether the structure on the subject property was that situation or something else. So it sounds like the hearing officer, if this is the information they relied on, nobody confirmed. I mean, you have the appellant saying it's 3 or 4 units. You have the property appraiser saying it's 2 to 4 units in that one structure. And the hearing officer then goes and concludes that there's 2 single-family homes on the property, and maybe she relied on Mr. Hisney saying it might just be like an attachment to it, kind of like a mother-in-law suite or something that's not considered a duplex then. But he said, I can't confirm that. So it seems to me that there are a lot of issues about this, that it could be that you have a 15-foot easement for 4 units. And I'm not an expert on easements, but I'm looking at the information that was provided to us, and it says if the easement serves 1 dwelling unit, a minimum of 20 feet is required. I mean, it says if there's 2 or more, it's got to be 30. Well, the hearing officer allowed a variance to go for 2 units down to 20. So maybe this isn't cast in stone. Maybe if you have 1 unit, you can go to less than 20. I don't think it's advisable based on what that easement is used for, but they've already carved off 5 feet for utilities. They're left with 15 feet. And it sounds like the evidence in the backup that we received says that there's 4 or more units out there. So I definitely see a real concern with this and what the hearing officer has concluded. I don't know if Mr. Hisney is there, if I'm reading this wrong, or there was something else that they went out and they verified that second structure is truly a single family home, but I didn't see it here.
Well, allow me to direct your attention to page 3A54. The bottom of that page where Ms. Lott is responding to questions from the hearing officers. And she states, and it goes on to the next page, there were plenty of emergency vehicles. They're able to come back to the very back parcel. There are 2 single-family residents on this particular property, which is unique. The only access we have to this property is via the current access easement here in Master Hatley. 2 single-family residences on which property, Miss Lott? Miss Lott, it's on. That's what we're here for, the 2 parcels. That's the only thing that's back there. So there is testimony from the applicant at the time about the number of dwelling units on the property.
Okay, but that's the applicant, and in these proceedings, you don't necessarily just take everybody's word. If the property appraiser was out there and they're experts at this and they determined based on their visit, it was 2 to 4 units, I don't know why that wouldn't override what any applicant may tell the hearing officer. And maybe there's not an answer for that.
I'm simply pointing out what's in the transcript. I'm in no way inferring what weighed on the hearing officer's decision into that matter. I'm simply pointing out you had raised a question about whether there was testimony or evidence in the record regarding number of units other than what was presented by the appellant. So that's all I'm doing, sir.
Thank you.
Mr. Hisney, from what we see in the record, would you regard that as a multi-dwelling requiring the 30-foot easement?
I don't know how many dwelling units are on the property by any personal knowledge, so I wouldn't be able to answer that, sir.
Thank you. Any other board members have any questions of Mr. Bentley or staff? So we are at that point where we can either affirm the decision of the Lujo, or we can remand it back to them so that we can have a discussion. I'd like a motion to either affirm or remand.
Mr. Chairman, I move that we remand this decision back to the land use hearing officer because of the concerns that we've mentioned here. In regard to revisiting the 6 questions, to verify the information that they relied on, and to go back and with verified information, go back on the 6 findings that they look at for any variance.
There a second?
I'll second. This is Brad Cornelius.
Any discussion on the motion?
And
Mr. Chairman.
board members, this is Cameron Clark. Just wanted to ask, as part of the motion to remand, as much specificity as the motion maker can make in terms of which or how, which of the variance criteria that they want the hearing officer to focus to get additional competent substantial evidence on, or if there's any other aspects that they would like the hearing officer to focus on at the remand hearing if the motion passes. Thank you.
Thank you, Mr. Kolek.
Madam Chair, who was the maker of the motion?
Mr. Campbell, seconded by Mr. Cornelius.
Madam
Thank
Chair,
you.
Mr. Campbell, I could make a suggestion for the motion maybe to address this, if you're okay with this. My thought is that part of our motion would be that the land use hearing officer readdress items 1, 3, 5, and 6, related to specifically, as Mr. Campbell said, what is the real configuration of the dwelling units? What is actually out there? Because that's an unanswered question. And also addressing the concern about the code enforcement case, as well as potential misrepresentation early on in the case. And I think those are the three main issues that I hear that I think should be further investigated and applied to number 1, which is hardships. Number 3 is with the rights, property owners. Number 5 is illegal action. And number 6, substantial justice.
Did you mention 5?
Mr. Campbell, do you agree to modify your motion to include those criteria?
Yes, I do.
Is there any further discussion on this motion? With that said, I, Ricky Bauman, Chair, vote to remand. Vice Chair,
I agree to remand.
Mr. Evans,
I vote to remand.
Mr. Cornelius. Mr. Campbell. Sorry about that.
I vote to remand.
And Mr. Schwartz.
I vote to remand.
And the vote is unanimous, 5-0, to remand it back to the land use hearing officer for the criteria on the amended motion. Ms. Rodriguez, are there any more appeals today?
Just a moment. I'm trying to get there. Page 2, item 1A, Appeal 21-1309 for variance 210802. This is continued to the February 4th hearing at 2022 at 1 p.m. Mr. Wang was having some technical difficulties attending the hearing, so we will reschedule.
Okay, thank you.
And for the record, Ms. Rodriguez, you said 1 p.m. Is it 1:30 p.m.?
1:30 p.m.
Okay, thank you.
Same location.
And I believe we have one set of minutes to approve.
I believe there are 2.
Okay.
March 5th and the October 8th.
March and October?
Yes.
I will make a motion to approve the March 2021 and the October 2021 minutes as presented. Are there any errors or omissions in them? Hearing none, I make a motion to approve those minutes. Do I have a second?
This is Brad Cornelius. I second the motion.
Any discussion? All in favor?
Aye.
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 So moved. Ms. Rodriguez, I believe there is no further business for the board today.
There is no further business, and the next meeting is February 4th at 1:30, 2022.
And we are adjourning at 3:58 p.m. Thank you.
Thank you.